Good morning. The aim of this short video clip is to go through D1 and D2 for Unit 14 Employment Law, and I hope that I can go through all the essential information and criteria that you need to help you complete this particular assignment for D1 and D2. Right, the first thing you need to do for D1 and D2 is to select a business organisation. The idea of selecting a business organisation is to make or to bring to life the actual assignment that you're doing to help you develop the necessary skills in a working environment. So the idea is that you would apply employment law as if you were using it in a real world scenario. So what you must do to start off D1 in particular is to choose a suitable business organisation, and then all the conversation that you have must then be linked to that particular business organisation. I've given you some basic examples here. So you have Boots or Capital One or John Lewis or Marks and Spencer or any other business organisation that you can think about. And then the key thing here is you're thinking about what the responsibilities of the employer are towards their employees, and vice versa. In other words, what are the duties of the employee towards the employer. Also, you're considering how various pieces of law, including case law, affect the relationship between the employer and the employee and also benefit them. Now, so the first thing you need to have a look at relates to what we call implied duties. If you remember, we have express terms and implied terms in all employment contracts. Express terms are clearly written down in your contract, but implied terms are not written down anywhere, but they are an essential part of an employment contract. Without implied terms, I would suggest that the employment contract may not work as effectively as it should do. So the first thing to consider is the implied duties imposed on the employer. This simply means that you ask yourself, if I'm employed by Boots or John Lewis or Marks and Spencer, for example, what should I expect my employer to do for me? What are my employer's responsibilities? And I think we went through a few examples in the lessons 2 or 3 weeks ago, and one obvious implied duty of the employer is to pay your wages. We did say if you wanted to expand on that point, then there is no need for your employer to always provide you with work, because under the Employment Rights Act 1996 and sections 25 to 33, there's 28 rather to 33, there's evidence that the employer must guarantee payments towards you. So one implied duty of the employer towards you as a worker, an employed worker, would be to pay your wages. If they don't pay your wages, then they could be breaching their implied duty they owe to you and in effect breach their contract of employment. Now, the next thing you need to consider, once you've had a look at one example of an implied term owed from the employer to the employee, is to have a look at a case where the employer breached their duty towards the employee. And we've had a look at various cases in the lessons over the past few weeks, and Motorola and Davidson is a suitable case where there was evidence of possible unfair dismissal. So the key point about Motorola, apart from being used as a test to identify how much control an employer has over a worker, you can use this as a clear example of where the employer breached their duty towards their employee. You can't dismiss an employee without a good reason. Otherwise, you could be sued for unfair dismissal, which happened in Motorola and Davidson. So one, think about a duty, an implied duty owed by the employer to the employee, and then because it's a distinction task, you need to make your answer robust and complete by adding a case where the employer has broken their duty towards their employee. Now the next thing you need to look at is a duty or an implied duty the other way around. So this time you're looking at the employee. If you're employed in a business organisation, what would be your responsibility towards your employer? And again, one of the cases we looked at right at the beginning of employment law was the case of Pepper and Webb. And the main duty in that particular case, which rolls on to all employees in different working environments, is that so long as you're asked to do something which is reasonable and lawful, you must do it. And the case of Pepper and Webb, if we just move to the next slide, the case of Pepper and Webb is a fantastic case to refer to prove that if you as a worker classed as an employee breach your duty to obey reasonable and lawful orders, then your employer can take action to dismiss you. So this time what we've looked at is the duties of the employee, and we've backed that up by a case. Now, after you've looked at, and I've just given you one example of the implied duties of the employer and the employee, you must look at least 3 examples of the implied duties of the employer and 3 examples of the implied duties of the employee, and support your answers with cases or legal authority. Now, moving on from there and still on D1, you then need to refer to suitable statutory authority where you apply these laws, these statutory authorities, to the working relationship between the employer and the employee. So the question here is, you would ask yourself, what is the relevance of the Employment Rights Act 1996 to the working relationship of the employer and the employee? You would then go on to ask yourself, what is the relevance of the Equality Act 2010 to the working relationship of the employer and the employee? You could also consider the Health and Safety at Work Act 1974. Why is that important? How does that benefit the employee? What responsibilities does that impose on the employer? And so on. So if we have a quick look at the first Act of Parliament, you've got the Employment Rights Act 1996, and it suggests an employer may carry out redundancies, so long as those selected for redundancy are not selected unfairly or there's no evidence of discrimination. So the employer can make employees redundant, for example if they're reorganising, or if the job that the employee is doing no longer exists, or if the employer decides to move business from one part of the country to another part of the country. There are rights that the employee would have, such as the chance to look for work, and so on and so forth, and various support that the HR department would provide for the employee. But under the Employment Rights Act 1996, the employer may make an employee redundant. Also under that same Act, under Section 1, the employee is entitled to a contract of employment or particulars of employment within 2 months of engagement. The same Act under Section 8 clearly specifies that the employee must be given an itemised pay slip to identify things that have gone into their pay and things that might have been deducted, and that gives the employee the chance to make sure that there's been no illegal deductions from their pay slip. If we move on to the Equality Act 2010, I think most of the content there, or some of the content in the Equality Act 2010 is fairly obvious and straightforward, and one of the important ones is based on 9 protected characteristics. The employer is not allowed to discriminate against the employee. In addition to that, the employee is entitled to equal pay if they can prove like work rated as equivalent or work of equal value under Section 65 of the Equality Act 2010. So the key point here is, in order to achieve D1 for this particular part of your answer, make sure you refer to at least 2 Acts of Parliament and ask yourself, how do these Acts of Parliament help the employee in particular in the workplace, but also how does, or what responsibilities do certain legislation such as the Employment Rights Act 1996 and the Equality Act 2010 and the Employment Rights Act 1974, the Health and Safety at Work Act 1974, what responsibilities do they impose on the employer? So that's a quick summary of what you need to put in for D1. D2, again, very similar to M2, is slightly different in that you're required to find a suitable case, an employment law case, and then analyse the content of that case. Okay, so that's the first point there. So choose a suitable employment law case. You can have a look at suitable newspapers, broadsheet newspapers, the Times, the Guardian, the Telegraph, but my suggestion would be Westlaw has a large collection of employment law cases, and finding a suitable case in Westlaw might be very useful. Otherwise, some of the cases that we've already covered in employment law, such as Motorola and Davidson, Cassidy and Minister of Health, Ready Mix Concrete and Minister of Pensions and so on, are all suitable cases that you can use so long as you treat the case in detail, analyse the actual statements by the judges, and find out what the main problem was between the employer and the employee, and eventually the conclusion of the case. So that's the point here, evaluate the legal argument. So once you choose a case, similar to what you've done in M2, the case was Lister and Romford Eyes, find out what the case is all about. So you would have to read the facts of the case and identify what the dispute was about. And it goes without saying that in all employment law cases, there normally is an issue. Something would have gone wrong between the relationship between the employer and the employee, and your task will be to find out what that dispute was all about. Okay? And then you draw conclusions as to whether you agree with what the court decided, even though in reality whatever the court decides is what stands. But as an academic exercise, you might argue for or against the defendant or the claimant. So do put in what your opinion is, even though, as I suggest, that has little relevance really apart from academic discussion. Okay, so that's the point about choosing a case from Westlaw, which I do recommend, because some of the newspaper cases don't give you a lot of detail, but Westlaw cases are full cases and they discuss the actual facts of the case in a lot more detail. Okay. Right, this point is all to do with making sure that whatever case you choose has been completely proven. In employment law cases, because employment law falls under civil law, the standard of proof, in other words, the amount of evidence you have to provide, is what we call proof on a balance of probabilities, which simply means that it's more likely that either the employer or the employee was right in what they're alleging took place between themselves. Okay. And then, as already stated, draw your conclusions as to whether you agree with the decision or not, and make sure you summarise the key facts, in the best way that you can. And in a nutshell, that is a quick summary of D1, where you're mainly looking at the implied duties of both the employer and the employee. You're looking at acts of parliament that affect the relationship. So how does an act of parliament benefit an employee? How does an act of parliament impose responsibility on an employer, and so on? And also in D2, it's completely different. You're picking a case or choosing a case, talking about what happened in that case, identifying what was held in that case, identifying the ratio decidendi, the legal principle of that case, and then drawing a brief summary as to what you think about the case. And that in a nutshell is what you need to do for Unit 14, Employment Law D1 and D2. If you have any questions, please don't forget that you can always email me or arrange to speak to me in the office or in the classroom. Thank you for watching this short video clip.